If you work an hourly job in Virginia, build houses, wait tables, stock shelves, or get paid overtime when you work more than 40 hours a week, and your employer made you sign a paper saying you can't work for a competitor after you leave, that agreement may now be illegal. Your employer may be facing a $10,000 fine for every worker they forced to sign one. On July 1, 2025, Virginia dramatically expanded who is protected from non-compete agreements. These are contracts that try to stop you from taking a job with a competing company after you quit or get fired. The law doesn't just protect low-paid workers anymore. It now protects anyone classified as non-exempt under federal overtime law, which covers millions of Virginia workers, regardless of how much they earn. Most people who signed one of these agreements have no idea it might be unenforceable. By the end of this video, you will know exactly what Virginia's law says, whether it applies to your situation, what your employer is and is not allowed to do, and what steps to take if you signed one of these agreements after July 1, 2025. This falls under Virginia state employment law, specifically your rights as an employee to change jobs without your former employer controlling where you can work next. The law is called the Virginia Non-Compete Act, and it appears in the Virginia Code under Section 40.1.28.7:8. A non-compete agreement, also called a covenant not to compete, is a contract between an employer and a worker that restricts the worker's ability to work for a competitor or start a competing business after leaving that job. These agreements have been used for decades, but Virginia has been steadily tightening who can be forced to sign them. The original version of this protection took effect on July 1, 2020. At that time, Virginia banned employers from using non-compete agreements against what the law calls low-wage employees, workers earning less than the state's average weekly wage. When that law passed, the threshold was around $62,000 a year. On March 24, 2025, Governor Glenn Youngkin signed Senate Bill 1218 into law. The bill was written by State Senator Richard Stewart after one of his constituents, a construction worker who built docks for a living, was buried in 2.5 years of litigation by a former employer over a non-compete agreement he didn't even know he'd signed. The new version of the law took effect July 1, 2025. It added a second category of protected workers that has nothing to do with how much you earn. If you are classified as non-exempt under the Federal Fair Labor Standards Act, meaning you are legally entitled to overtime pay when you work more than 40 hours in a week, you are now protected from non-compete agreements in Virginia, no matter what your salary is. That expansion means this law now covers a significantly larger portion of Virginia's workforce. Any non-compete signed or renewed on or after July 1, 2025 with a protected worker is unlawful. Virginia law now says this: no employer in Virginia can enter into, enforce, or even threaten to enforce a non-compete agreement with any employee who qualifies as a low-wage employee. As of July 1, 2025, low-wage employee means two things. You qualify if either one is true. First, if you earn less than Virginia's average weekly wage, which for 2025 is $1,463.10 per week, or just over $76,000 a year. Second, if you are classified as non-exempt under the Federal Labor Standards Act, meaning you get overtime pay when you work more than 40 hours in a week, you are automatically protected, even if you earn well above $76,000. Being paid a salary does not automatically make you exempt from overtime. The Federal Fair Labor Standards Act uses a two-part test: your salary level and your actual job duties. You have to meet both tests to be exempt. If your job involves non-managerial work, or if you don't supervise other employees, or if your primary duties are not professional or administrative in nature, you are likely non-exempt, even if you are salaried. The law also explicitly bans employers from threatening to enforce these agreements, not just actually enforcing them. If your boss or your company's lawyer sends you a letter threatening legal action if you take a job with a competitor and you are a protected worker, that threat itself is a violation of Virginia law. The moment you receive that threat, the clock starts on your right to file a civil suit. You have 2 years from the most recent triggering event. the date you signed the agreement, the date you learned about it, the date you resigned or were fired, or the date your employer threatened or tried to enforce it, whichever happened most recently. If you file that suit and win, the court can void the agreement, order your employer to stop the enforcement, award you any wages or compensation you lost because of the illegal restriction, for example, if you turned down the competing job out of fear, award liquidated damages, a set dollar amount meant to compensate for harm that is hard to calculate precisely, award attorney's fees and costs, which means many employment lawyers may take these cases on a contingency basis, meaning no upfront cost to you. $76,081 per year, or $1,463.10 per week, is Virginia's average weekly wage for 2025. That is the salary threshold. If you earn less than that, you are automatically protected from non-competes, no matter what your job duties are. Even if you earn significantly more than that, you can still be protected if you are classified as non-exempt. The federal salary floor for exempt status under the Fair Labor Standards Act is currently $1,128 per week, or about $58,656 per year. That is lower than Virginia's threshold. If you earn less than $58,656 per year, you are automatically non-exempt under federal law, which means you are automatically protected under Virginia's non-compete ban. Earning more than that does not automatically make you exempt. You also have to pass a duties test. Cashiers, construction workers, customer service representatives, retail workers, food service workers, healthcare support staff, these workers are typically classified as non-exempt even when they are salaried, because their job duties do not involve management, supervision, or highly specialized professional work. $10,000 is the civil penalty per violation that a court can impose on an employer. That is not an automatic payout to you. It's a fine the employer faces if a court finds they violated the law. It means employers are now facing real financial consequences for using these agreements with protected workers. 2 years is how long you have to file a suit. The clock does not start from a single date. It starts from whichever of these 4 triggering events happened most recently: signing the agreement, learning about it, resigning, or receiving a threat to enforce it. If you signed a non-compete in August 2025, quit in January 2026, and received a threatening letter in March 2026, you have until March 2028 to file. After that deadline, in most cases, your right to bring a claim is permanently gone. This law is new enough it only took effect July 1, 2025, that there are no published court rulings on cases brought under the amended version. The story behind the law is itself a real-world outcome. Senator Richard Stewart told the Virginia Senate Commerce and Labor Committee about the constituent who inspired the bill. He built docks for a living. He left his employer, went to work for himself, and then joined another company. His former employer sued him over a non-compete agreement and, in Stewart's words, buried him for the next 2.5 years in litigation. All he could do was barely make enough to pay his lawyer. That case never went to trial. It never resulted in a published ruling. It cost that worker years of his life and tens of thousands of dollars in legal fees, all over a restriction that under the new law would now be illegal. Stewart's conclusion: there's just no reason why they should be subject to the non-competes. That's the harm this law was designed to prevent, not workers stealing trade secrets, not executives walking out with client lists. Workers who build things, serve customers, and stock shelves being threatened with lawsuits for trying to take a better job. If you are a Virginia worker and you think this law might apply to you, find out if you have a non-compete agreement. Pull out your original job offer letter, your employment contract, your employee handbook, and any severance agreement you signed. A non-compete clause may be buried inside a larger document. It does not have to be a separate piece of paper. Look for language about restrictive covenants, covenants not to compete, or restrictions on working for competitors after you leave. Determine when you signed it. If you signed before July 1, 2025, the new expansion does not automatically void it, but the original 2020 law may still protect you if you earn less than $76,081 per year. If you signed or renewed the agreement on or after July 1, 2025, the full protection of the amended law applies if you are non-exempt. Determine your classification under the Fair Labor Standards Act. Do you receive overtime pay, time and a half, when you work more than 40 hours in a week? Is your pay primarily based on an hourly rate? Are your job duties primarily non-managerial and non-professional? If yes to any of those, you are likely non-exempt, and the non-compete ban protects you. If you are unsure of your classification, consult an employment attorney before taking any action. Misunderstanding your classification can be costly. If your non-compete is illegal and your employer has not threatened to enforce it, you may choose to simply start your new job and monitor the situation. Many employers use non-competes as deterrents but never actually sue. If your employer has sent you a threatening letter or told you they will take legal action if you accept a competing job, you need to document everything